Professor Murthy, in addition to doing tech support for our speaker series, most of the time is a professor of law and public policy here at Northeastern and co-director of the Center for Public Interest Advocacy and Collaboration. She was formerly in the White House Council on Environmental Quality from 2021 to 24, and focuses on a variety of different issues, including legal barriers to achieving environmental justice and addressing climate change, which of course made her, I thought, a wonderful respondent for today. So Professor Rodríguez-Garavito is going to speak for about 40 minutes, something like that. And then Professor Murthy will do a response, and then we will open it up. So a warm welcome and thank you.
Thank you, Lina. It's great to be here, my first time at Northeastern. I've always admired the work that is done here, and especially at the center. So what I share with you today is this book, which is available online, as you know, because some of you already read some chapters from it. But given that the reading is available and the book is out, I also want to give you kind of part of the background story to the book and to this field of research and practice, because this book was researched and written in collaboration and in conversation with many researchers and advocates and lawyers from around the world that have very actively advanced the ideas that now became officially kind of recognized by some of the highest courts in the world. So what I'm going to do, because I do need my slides. So recently, this is the ICJ, the International Court of Justice, full bench. Some of you may know that's not in the book because the book was published in June and it was finalized in December, just in time to become immediately outdated. I knew that these two advisory opinions were coming down, but also I have to publish the book. But this is the full bench of the ICJ, which handed down really a landmark advisory opinion on climate change in July. This is another court. Does anyone recognize this image? What court made this? Exactly, it's the Inter-American Court of Human Rights. And I was actually there. This order was taken by a team member, one of our colleagues at the Climate Law Accelerator, when we presented before the court the arguments that my colleague Jackie Gallant, who's sitting in the back, and I and others made to the court about the state and corporate duties and responsibilities to curb carbon emissions and speed up climate action. So these two courts handed down their respective advisory opinions. Don't know how familiar people are with that language, but in case you are not, these peak courts can hand down two types of decisions. One is kind of conventional rulings in contentious cases, but they also get consulted by governments on the state of international law on a particularly controversial or emergent issue, like climate change and human rights. So in this case, in the case of the Inter-American Court, it was the governments of Colombia and Chile who went to the court and said, can you help us understand where we stand in terms of state obligations to mitigate climate global warming, and also help communities adapt to the already inevitable consequences of global warming. And then can you help us understand what the climate justice implications are of the whole range of international legal norms that are relevant for this issue, ranging from the Paris Agreement to, in this case, the American Convention on Human Rights, and in the case of the ICJ, the whole range of treaties that could potentially be applicable to the issue of climate change. By the way, that was one of the questions. Well, is when it comes to climate law, does the Paris Agreement exhaust kind of the legal sources in international law? Do states have to act in line with the Paris Agreement only? And this is what's called lex specialis. Or do they also need to take into consideration the promises and the commitments they had made in other international agreements, like the whole range of human rights treaties that states around the world have been signing for the last 75 years or so. So all of those issues were at stake, and because these two courts went well beyond what any observer would have expected. If someone tells you these days, I knew that the ICJ was going to come out in strong defense of the bindingness of the Paris Agreement and that the 1.5 degrees cap in global warming, that everyone knew that that was binding. That's not true. So that is that the ICJ, with the wisdom of the day after, you can say that, but even the day before, and I talked to some of the climate negotiators who were there in the room the day that the ICJ decided hand down the opinion, and they had to change their pre-releases like as the court was reading the opinion, because no one expected the court to be so assertive in saying that the key pieces of the climate regime, meaning the 1.5 degree limit, the state obligations to reduce carbon emissions, help communities adapt, and potentially compensate vulnerable countries and communities for the damages that high emitting countries and potentially corporations have caused. All of that, all of that was not new, but certainly it was not. It had been said by courts at that level. So this is exciting, but at the same time, I wanna at least qualify the enthusiasm about these two AOs, in that many observers and certainly many journalists have said that these are transformational decisions, that they for the first time asserted that these duties and responsibilities exist in international law. In reality, these two decisions are more of a consolidation of a 20-year process that some of you read about. And the hard work was done not by these two courts, as interesting as their decisions are, but by many activists, lawyers, social movements, communities, normal entrepreneurs, UN special rapporteurs, a whole range of individuals who for 20 years advanced ideas and doctrines that, as you know from the book, initially were seen as highly unlikely, improbable. I should have included in the book a quote by the American psychologist William James, one of the founders of US psychology, who once wrote about new ideas that they first are seen as very unlikely and even preposterous. Then later on, they're seen as obvious. And later on, and then the critics themselves will say that they themselves invented this. Right? So I've seen that happen over and over. Now I'm seeing this, and these days I spend a lot of my time and our team's time on rights of nature work. Exactly the same thing happened. I saw this happen a few years ago when rights of nature would be seen as something, for hippies and mystics, and now that this court said that rights of nature are binding, at least at the inter-American level, everyone's jumping on that bandwagon, right? So whenever you say whenever you hear as a law student that something is unlikely, well, it may be unlikely for a little while, and 20 years is a short period of time in international law, and because the law is so backward-looking, and we're always looking for good reasons, learning the precedents and how things have been done, legal scholars and legal practitioners are biased against change and the possibility of change. So I wrote this book partly to tell the story of rapid change and to remind people who are very much around that some of them used to be very skeptical about the idea of framing climate change as a human rights issue. This is why it was my delight to include some of the quotes from the pioneering lawyers in the chapter 1 and chapter 2, who, when they went to large organizations, and won't name names, but the large international human rights NGOs, and said, could you help us with this little case we're trying to file on behalf of the Inuit community against the US? for the climate harms that Arctic community is feeling. They're having to relocate. Their cultural practices are no longer possible in the seasons that they used to be because those seasons are changing. And those organizations said, well, that's not a human rights issue. That is an issue for polar bears and for environmentalists and climate scientists. You know, stretching the law and the field of human rights to encompass climate change would take away from the serious human rights issues. You know, so again, another caveat: when people say these are the human rights issues, those are not the human rights issues, always put a question mark on that. Who says that? And 20 years later, you will be hard pressed to find a human rights organization at the international domestic level that is not doing climate advocacy and litigation. So things can change very quickly. So that is why this talk is basically a kind of a time tunnel. I want to take us back to 2005 and see what happened between then and now that led to these results and these transformations. So this is Sheila Wood. Here you read about her pioneering petition. Basically, for those of you maybe on Zoom who have not read the book, and what she claimed is that the U.S. government's failure to curb carbon emissions and the policies and the tax incentives, the subsidies that the government was giving to fossil fuel corporations, they all were causing very direct harms and very clear human rights violations on the ground. And that those human rights violations were justiciable and that the government should be held accountable for that installment. This was not a contentious case, so forgive me for stretching the kind of the language there, but that's the idea here. What the commission said, if you read the response from the commission, you will see kind of a classic lawyerly move of trying to dodge the question. They didn't know what to do with it. They never heard of anything like that and said, well, we don't see basically if you asked ChatGPT to translate that language into regular kind of everyday language itself, they said that this was not a human rights issue. Much more convoluted jargon style. And because, to be fair to the commission back then, that this was very new. And yet, activists and lawyers, she worked with lawyers from Earth Justice and CL, and then other organizations did filed similar cases, similar complaints, similar petitions in different jurisdictions around the world. And perhaps the decision that made the news and that certainly showed people like me that there was something here worth pursuing was the Urgenda case in the Netherlands. Well, 2013, the lower court decision came down in 2015, so fully 10 years after the Inuit petition. And this was the first successful lawsuit that framed climate change as a human rights issue, and that led to a favorable decision for the plaintiffs that forced a national government to increase its ambition with regards to lowering carbon emissions. And basically, what the lower court said in the Netherlands, and then was confirmed 5 years later by the Supreme Court, is that the fact that everyone pollutes is not an excuse for any given polluter not to do their part. Right? So regardless of what the US or China or Brazil or the UAE does, the Dutch government has this issue, responsibilities and duties of their own to lower carbon emissions in line with the science regularly updated by the IPCC, the Intergovernmental Climate Change. So that was first. That's when I got involved in this field. In 2016, I participated in studies organized by Brazilian activists and lawyers, and that came from very different quarters. And this gives you kind of a flavor for the diversity of this field. That meeting was attended by children's rights advocates, by law professors from constitutional law and public law in general, kind of scholarship and practice, and then by a range of environmental and human rights organizations. Those organizations eventually filed a case in 2019 that led to a 2022 decision that I'm going to talk about. So this is around the time, and this is, I have some numbers here. Around the time, you see the increase in cases after the mid-2010s. In the book, I try to show how this explosive rise of cases after the mid-2010s had something to do with the Paris Agreement. The Paris Agreement did not say anything much about human rights. It only made kind of very, very lateral mention of it in the preamble, but it gave the world a set of goals that people could rally around. It did not specify how binding those commitments were. It has been done more recently by both high courts, the ICJ and the Inter-American Court of Human Rights, and also the European Court in a case from last year. But it created some sort of a set of expectations of behavior, mostly for governments and to a lesser extent for corporations, to do more about climate change. So what lawyers and eventually judges did in most of those 467 cases that I analyzed in the case, so this is the universe of rights-based climate lawsuits filed between 2005 and 2024, the end of 2024, so 20 years. What those lawyers did was to invoke those goals, the goals of keeping global warming to 1.5 degrees, the goal of having all states submit nationally determined contributions or pledges, right, to the COP summit system, the UNFCCC, and in general commit to doing more and more quickly against climate change. And so, and they turn those very vague commitments at the global level into binding commitments at the domestic level. So this was a way to domesticate and to harden the commitments and the promises that had been made in Paris and make them justiciable at the local level. So this is what explains most of the cases, the strategy of most of the cases. I won't go into the details of the numbers, partly because many of you already read this, and partly because I'm happy to move into all of this in the Q&A if there's interest. But what I want to do in the time that I have is to give you kind of the high-level account of what happened. The main finding here is that the overwhelming majority of cases have had to do with mitigation, meaning pushing governments and to a lesser extent corporations to lower carbon emissions. Very few cases have had to do with adaptation, meaning dealing with the need to, as the name says, adapt to the already inevitable consequences of climate change. So putting up walls to protect communities against sea level rise, or setting up early warning systems to let people know that a hurricane is coming their way. All of that are adaptation measures. And finally, loss and damage has to do with climate reparation. Because there are effects, sadly, that communities and individuals can no longer adapt to. The damage is done. So the only act of justice that remains to be done is to compensate those individuals and those communities and those countries. Like, for example, if you had to forcefully relocate, if you had no choice but to leave a coastal area in Bangladesh, we've done some work with Adam and colleagues in Bangladesh, and we interviewed communities that had to relocate because of sea level rise in the coastal areas of Bangladesh. Well, they can no longer adapt to climate change. They had to go through a fundamental change in their life conditions, and the question here for the law is how can they be compensated for that, and who should compensate? Who should pay for the cost, economic and non-economic costs that they've incurred? Most of the cases have been filed against governments, although that is changing. But of course, here the blind spot is corporate accountability cases. This is changing partly because, at least in Europe, more and more cases have been filed against, are targeting corporations, and climate science is making these easier to do. This is very hard. It's in general asserting the responsibility of specific corporations for fossil fuel or other types of corporations for climate harms is hard, but the science is making it easier because these days you can attribute. There's a fantastic database on corporate leaders. This is where what's called the carbon majors database, so you can know historically how much has been emitted by each fossil fuel company. We can go into the accounting. I'll leave it there for now. The science, what science has been adding is kind of more and more steps in the causal chain, from those emissions to the probability of extreme weather events happening, like heat waves or hurricanes or droughts or floods. And then more recently, estimate the dollar value of those damages. And so lawyers now have much better evidence that they can leverage to file these types of claims against not only governments, but also corporations. And then the regional breakdown is pretty even. It used to be the case that in the 2010s, Europe was kind of the headquarters of this type of litigation after Urgenda, but this is much more evenly distributed these days. And finally, you might be asking, well, in terms of the results, what are the outcome? Of course, many of these cases are still pending. These cases take years and years to litigate. And because many were filed after 2015, they're still pending. Now, among the ones that have ended with definitive rulings or decisions, the breakdown is relatively even. Of course, there's more for defendants than for plaintiffs, but for a field where the doctrines have been in flux, where the claims are relatively novel, this is remarkably encouraging if you care about climate action, because that means that 20%, roughly say a fifth of the cases have ended with decisions for the plaintiffs, and that many of these cases, after the two advisory opinions, I think that they're more likely to go for the plaintiffs because now the law is clearer, and also we'll see very likely a new wave of lawsuits and legal actions of this. Just to give you a flavor for this, I'm happy to go into the details of any of these cases, but I want to give you a little album of some of those actions. So we already talked about Shelo Gutier, Urgenda. This is Legari, was the first climate adaptation case happened in Pakistan. This is the judge who wrote the opinion, Justice Ali Shah. And this was a case that held the government accountable for not implementing and enforcing its own climate adaptation laws and legal framework. This is a case, Neubayer in Germany, that to my mind is one of the most sophisticated and interesting court decisions on climate change by the Constitutional Court of Germany and filed by the youth movement in collaboration with well-known lawyers. This is the case that I was referring to in Brazil. The interesting feature of this case is that it was the first one to frame the Paris Agreement as a human rights agreement. But this justice said, Justice Barroso, who's now the Chief Justice of the Brazilian Supreme Court, what he said is like, climate change is such a fundamental human rights issue. It really affects the whole range of human rights, from the right to life, from the right to the right of housing. People need to relocate, the right to health. We see the consequences of global warming on people's health, and for example, in extreme heat situations. So the Paris Agreement should be construed as a human rights treaty, and because in many continental law jurisdictions, especially in Latin America, human rights treaties have a supralegal status, meaning that they're somewhere between the Constitution and regular laws. This gave the Paris Agreement a pretty forceful role in the Brazilian legal system. And this led to the court mandating that a fund, the climate fund, that has been established with European donations to fight deforestation in the Amazon, which the Bolsonaro administration had decided to sit on, that had to be reactivated, and the money had to be used for the purposes that it had been donated. In the US, the first successful case after many attempts was the Hell versus Montana case, which leveraged state constitutional law, specifically language on the right to healthy environment in the Montana Constitution, and led to a decision eventually confirmed by the Supreme Court of Montana to the effect that the Montana government had violated young people's rights. Many of these are up to roughly 20% of these cases have been filed by young petitioners or plaintiffs. The youth climate movement has had a key role in this wave of litigation, of course, working with expert lawyers and organizations. And after literally like 50 attempts, the organization that led this case, the Our Children's Trust, finally got a positive decision, and that added the U.S. to the picture from which it had been kind of missing for almost 20 years by then. And then the last case that I want to mention that I haven't alluded to is the Klima Seniorin case, filed by the Association of Elderly Swiss Women. That's kind of the translation of Klima Seniorin, who took the Swiss government to court and won for the disproportionate impacts of climate change on this population. And the court asked the Swiss government to speed up and ratchet up its climate mitigation commitments in line with, again, with the science available in the IPCC reports. We already talked about the Inter-American Court and then the ICJs. So I'm going to start wrapping up by giving you a flavor for the contours of this field. And chapter 5 of the book is all about the impacts of these cases, so I won't have time to go there, but if you're interested in the consequences, the effects that some of these cases have had, I'm happy to elaborate on that. Chapter 3 is about what's unique about this field. There are many other fields of human rights law and practice, but there are many other fields of subfields of environmental advocacy and lawyering, pollution, biodiversity, in case of human rights, or civil and political rights, socioeconomic rights. So what's unique about this? One thing that is unique is that this field brings together two legal regimes that had so far run parallel to each other. So there was the whole infrastructure. You probably are already familiar with that infrastructure of treaties, of treaty bodies, of UN, the UN Human Rights Council, human rights courts, and ombuds people in different jurisdictions and countries. So human rights has a whole legacy, a whole normative and institutional legacy that was busy doing other things before climate change came around as a major existential issue. And then, on the other hand, the 20-year history that is on the book saw the emergence of a whole new regime of international governance, which is climate law. That's the Paris Agreement, it's the UNFCCC, and so on. What this field does is bring those two regimes together. And the people who did that, really the people who led this convergence were the environmental lawyers, opposed to the human rights lawyers. As if you read chapter 1, you saw my quotes from some of the interviews where some of the lawyers who filed their first cases after the Olympic petition said that they saw that the human rights field had all these mechanisms readily available. And because they had tried to fight climate change through other means, through campaigning, through participation in the climate negotiations, the COP summits, and nothing had worked. They said, well, why don't we borrow from these other guys all these ideas and all these institutions? Can we sue before the Inter-American system? Can we take some of these claims to the UN human rights system? And they read the landscape very strategically and managed to create this convergence. So in this coming together, one of the striking features is that social movements have been quite prominent. Some other fields are lawyer-led. This is more of a collaboration between activists and lawyers. In fact, many of the cases that have had the deepest kind of repercussions in public opinion in the law were filed by the likes of Greenpeace and Friends of the Earth, or AIDA in Latin America, or Conectas in Brazil, or Natural Justice in Africa. So these are advocacy organizations. Or Urgenda itself is not a human rights organization, and Urgenda was filed by the organization itself and more than 800 Dutch citizens. So that has given this wave of litigation a social movement flavor to it, which I think, don't have time to comment on this, but happy to say more later. I think this is a good thing because it pushes the boundaries of what lawyers think is doable, and also it keeps some momentum beyond the favorable ruling that can be translated into pressure for implementation of those rulings, which sometimes is challenging because there's backlash or some governments drag their feet on implementation. Then importantly, this has been a field where climate scientists, climate lawyers have each done their part. Climate scientists have been very insistent in keeping their independence as they should, but as their evidence, as their science showed more and more kind of impacts, it showed that the climate change has become a truly kind of urgent issue that needed urgent attention. They became much more vocal in warning the world against about the impacts on human individuals and communities of what they were seeing in the climate system. And if you read the 2018 report by the IPCC, you see the change of language. And they used to talk and write about climate change as a high level, it's an abstract issue of climatology and hard science. In that report, scientists decided to speak and to offer evidence about the very direct consequences for human communities and human individuals. So that also marked the turn towards lawyers using more deliberately and more strategically the mounting evidence on these impacts coming from climate scientists. And if you want to see a good example of how climate lawyers have leveraged the evolving science of climate change, you can watch the recordings of the Kell versus Montana case, where the lawyers for OCT, or Children's Trust, did a great job of mobilizing the best science. They called some of the top climate scientists as witness, and the judge got a chance to cross-examine. And so that was a really good process of tapping into the strength of science as a form of evidence for climate change claims. And finally, the ideas in this field have spread very quickly. In a matter of months, you could see how, for example, the agenda decision from 2015 was being invoked by South Korean lawyers for a new case before the South Korean Constitutional Court, or how that precedent was replicated in one European country after another. And the conversation and the cross-learning has been such that in the book I talk about an open source strategy here. Literally, litigants, some of the key litigants have opened their code. They say, like, this is how you do it. And then they've set up networks, like the Climate Litigation Network, or some academic organizations like the Savings Center or Own Climate Law Accelerator have curated databases to keep track of strategies and of decisions, so that people can learn from each other. And this has led to much more cross-fertilization that is common in other fields. I'll end by, I said that I would not talk too much about the details of the law, but I'm just gonna flag some of the legal innovations, given that we're in a law school, that I'm happy to elaborate on. And this is based on the book, not on the advisory opinions, but remarkably, all of these doctrines that bubbled up kind of from the bottom up, okay, they came from domestic courts and legal actions and made it to the international scene. Virtually all of them were confirmed and further extended by the two advisory opinions more recently. So one legal development was the consolidation, with the emergence and consolidation of the right to a healthy environment. This was called by some diplomats kind of the newest human right. If you read chapter 1, or if you were interested in reading chapters 1 and chapter 2, I tell the story of how the idea of framing climate change as a human rights issue went hand in hand with the idea that there should be a standalone right to a healthy environment. And so many of the same normal entrepreneurs, many of the same organizations and advocates and scholars who advocated for the international system to recognize a new right, were also behind some of the cases that frame climate change as a human rights issue. So this is a development that is closely associated with all the cases that I mentioned earlier. I already said that the idea that 1.5 degrees of global warming maximum is not just a desirable outcome, but a binding goal. That was not clear in the Paris Agreement. It took all of these legal actions to clarify that and to harden that commitment. Then expanded standing. Many of the early cases lost on standing. Imagine, and I was part of some of these conversations early on, where some courts and even some advocates and lawyers would be skeptical about Pacific Island, young people from the Pacific Island saying that they had standing to sue governments in the global north for the climate harms that they were experiencing that would probably force them to relocate because of sea level rise, making life impossible in those Pacific Island nations. But also domestically, it wasn't clear, for example, why, if deforestation was happening in the Amazon region, if that was the problem that for which the Brazilian government was being taken to court, why young people from São Paulo or from southern Brazil would have standing to sue the government if they were not directly suffering kind of the consequences of deforestation. Of course, we know, and as I said, even the critics today will say that the standing and the consequences, the impact of climate change work differently, because we literally all suffer the consequences of of emissions produced everywhere, right? So if you're a young person in Sao Paulo, the drought and that you're experiencing, the lack of water that Paulistas are experiencing every February or March, is very directly associated with deforestation in the Amazon. You could also make this more complicated and more sophisticated by saying that the climate system in the US or the climate system in Africa is also affected by deforestation in the Amazon, because it's one Earth, it's one climate system, right? But that was not obvious to courts and lawyers who are used to procedural rules and rules of standing that require direct impact on the ground, kind of a linear impact on the ground for anyone to file a lawsuit. So that standing was built out through these cases. Global and intergenerational justice. This was also entirely clear. It's not that this is all of this. I don't mean by saying that these ideas have become widely recognized now. I don't mean to say that the world is climate change is solved. We need to move on. But this is the same for a moment at the level of the law, right? Because for those of you, imagine if you're taking this class, you're interested in working for a better world. Those advocates, for good reasons, tend to see always the glass half empty, right? Because there's always kind of temptation to say, well, yes, there's so much violence against women, but so much also, which is true. It's also true that a lot of progress has been made since the 1990s, when the women's rights movement made this fantastic kind of achieved this fantastic treaty in the international system, the CEDAW system, that has spared the lives of many, many women around the world. So just for a moment, it's good to pause and acknowledge progress, and then continue to worry about the lack of progress, right? So, but intergenerational justice, for example, the idea that current generations need to abstain from behaviors like burning fossil fuels that will disproportionately impact the rights of future generations. That was not clear at the beginning of this wave of litigation. Partly because if you read the letter of the International Human Rights Declarations and Conventions, well, you could interpret them as saying that you could fully fulfill the rights of present generations while leaving no planet for future generations. Right? Because back in 1948, in the time of the UN Declaration of Human Rights, the idea that the planet was finite, that there were boundaries to growth, and all of that was not a preoccupation. The preoccupation of global justice was something else. And finally, I already said that there are duties to mitigate, adapt, and regulate emissions. And then this is loss and damage duty to restore and compensate. Of course, each of these lines would take anyone like half an hour to fully unpack, but I'm just gonna put it out there and start wrapping up here. This is, I'm not gonna say that I won't go into the impacts, but happy to comment on the difference that some of these cases have made, and also the backlash against some of these rulings and decisions. And this is our website in case you wanna check out the database behind the book. We also publish reports, case studies. So it's a resource, it's all open access, and it's there for everyone to use. Beautiful.
Mr. Ridley.
Perfect. Well, first of all, that was a fabulous talk. But before I talk, I would love to invite everyone to just stand up and take a second to stretch, because it is that moment in the afternoon. I know that I always appreciate that, and I feel like that we can have a conversation. And Is it okay if I take? So first of all, that was just a marvelous talk, and I want to say also just a beautiful demonstration on how to effectively use slide visuals to complement your remarks. And I also love that this project, first, the database that you compiled is just so impressive, as well as the fact that all these materials are open source, really just tremendous. I want to really focus my remarks on really three different aspects. And first, I should just say that part of this draws on my background as someone who has thought a lot about the human right to water. And I was really interested in your introduction, how you talked a little bit about that as a parallel movement. And so I wanted to reflect on some of the lessons that you learned, but from a different context, which is the evolution of the right to water under international law. The second is really thinking about norm development. And I thought that your book does a great job of thinking about, especially like your time tunnel image. You know, you said this is not pronouncements out of nowhere. This is really about norm development over time. And we have these moments where things become crystally sort of clear. So I want to think about that. And then I want to transition in sort of the third part and thinking about what this means for the US. Because obviously we see all of the things happen internationally, and then we see a very different narrative and a very different set of norms that are being promulgated in the US. And I'm very curious at your response to that piece of it. So first, let me just talk a little bit about the right to water, which is very briefly mentioned in your opening chapter. Like climate change, water was not referenced in any of the early human rights documents. And how many of you have seen the film, The Lorax? Remember this film, right? So it's interesting, and I want to think about this because, you know, it's interesting because the whole setup of this, the Lorax or the Dr. Seuss book, but the whole setup of the film is that all the air is terrible, right? And so they're sort of bottling the air. And we don't think about a human right to air. And part of it is that we sort of take for granted that we can breathe in the air, but certain things become so dramatically difficult. And you find advocates and people on the ground, the policy solutions are not working. And that's what we see in the climate. I mean, you articulate that really well, where there's just a sense of frustration about the fact that the climate regime is very complex, many different levels of governance, many different actors. It's very hard to figure out how can we actually address this problem in a meaningful way. And the fact that you had advocates looking over at the human rights world, environmentalists saying, wow, you know, we still need to be thinking about working on mitigation strategies and developing the renewable energy sources and working through, you know, regulation. In the US, we're thinking about how do we construe the Clean Air Act in a way that will actually cover greenhouse gases. That's really challenging, but that maybe there's another, you know, in a moment of crisis, looking and recognizing that we can call on and draw on human rights and think about that as a language. And one of the things that I think your writing, your talk really illustrates is this ability to translate. You talk about these two different fields, but part of it is that you are translating, honestly, very technical, dry material about how climate change works, how greenhouse gases works, the way in which you have to mitigate it. And if you're in that world of climate, it can get very technical very quickly. And yet what you see in these cases, people actually taking that language and bringing it down to a human level and saying, this is affecting me as a person. Fundamentally, this is about our right to live, our right to breathe. And I go back to my Lorax example, which is that, you know, we don't have a right to air per se. But if we were in a situation where we literally could not breathe, I think we would be seeing that evolution. Similarly, the right to water evolved, where you just had a series of crises around the world, concerns around privatization, concerns that governments weren't actually addressing water adequately. And you saw the same sort of steps, you know, where you can see this development pushing from civil society, pushing really the international actors and saying, okay, first let's work through the UN system. Let's see if we can get, you know, an independent expert appointed. Then we can get them set to a special rapporteur. Maybe, you know, words matters. We are all at a law school. We know how much words matters. The fact that you could get a reference to human rights in a climate conference of the parties, the COP climate document, like a soft law document, soft law, like it's not a binding treaty, but it's a report. And they're saying, okay, can we even get the word human rights in somewhere, right? All of these I think of as sort of little steps along the way that are building. And I think you're right that we will soon begin to see some real world impact in different ways. In the water context, I will say that one of the real world impacts was the way in which water was really being monitored globally through the Sustainable Development Goals. And you saw the translation of human rights language sort of merging with the way the public health folks and the water folks talked about you need water quality, you need water quantity, you need water accessibility, sort of that scaffolding of the social and economic rights. And this translation of law into policy has actually led to some material change. I think we will see something similar happening in climate, but I also agree with your bit of, and I appreciated your understanding that that the law is just one tool, that these cases is not the be all end all. This is just one strategy when in fact we are just at a moment of severe crisis. So that's sort of point one about water. Point two, I want to just think a little bit about norms and the way in which the law really does reflect norms. And I think this book really does a fabulous job of trying to reflect this. We in the US here experienced a moment back in the first Trump administration where we had a complete repudiation of global climate norms like we're seeing again right now. But at that moment, back in 2017, when the US pulled out of Paris for the first time, you had all these states and cities saying, hey, we want to support the Paris Agreement on climate change, which didn't actually make sense if you understand international law because they're not state actors, right? They were subnational actors. And so you talk a lot about norm entrepreneurs in your book, and you referenced it here. And I thought of these states and cities as actually norm sustainers because they weren't developing these ideas, but what they're trying to do is just keep alive these norms. And in the US here, just saying, okay, well, maybe the US is not going to be party to the Paris Agreement on climate change, but we can still keep those norms alive so that when the Biden administration came into office, and as was noted, I worked in the administration, and so we were able to kind of step back in and pick up where we left off. In addition, I want to share with you, I had the honor of working on an executive order called Revitalizing Our Nation's Commitment to Environmental Justice for All. This was one of the executive orders that I think it's been revoked 3 times. But a beautiful framed copy of it is in my office if you want to come check it out. But I want to read to you the opening line and talk about the relevance of sort of this norm generation at the international level and how it could have an impact in the US, even despite the current, despite our current political and legal context. The opening section of this executive order says, to fulfill our nation's promises of justice, liberty, and equality, every person must have clean air to breathe, clean water to drink, safe and healthy foods to eat, and an environment that is healthy, sustainable, climate resilient, and free from harmful pollution and chemical exposure. Restoring and protecting a healthy environment wherever people live, play, work, learn, grow, and worship is a matter of justice and a fundamental duty that the federal government must uphold on behalf of all people. That is very powerful words from the federal government. President Biden signed those words. It doesn't use human rights. We're not going to be able to probably get to that point in the US, but that came very close. Those were pretty hard fought words, I will say. And we were really proud of being able to get those into the policy statement. And part of it is, I think, a reflection of what's happening outside. And the fact that we may have a different language in the US, but it does in fact have an impact. Third point, so I've talked about water. I've talked about some of this, what I might call norm diffusion, and sort of maybe an Americanization of this norm diffusion and the norm sustaining. I just want to talk about the current context right now. So we are in a moment, and I will say that in preparation for this, I also re-listened to President Trump's talk for the United Nations as a way to kind of remind myself of the context that we are in. And we are in an interesting context, and I'm very interested in your thoughts on this.
The bar was very low. There's time to get this talking.
That was your
But obviously we're in a moment where there's a lot of pushback on even just the fundamental science, right? So the consensus, the global consensus that you talk about, we are seeing a rejection of that in the US. We are seeing a rejection of even just the ways in which our current laws are interpreted to encompass greenhouse gas regulations, i.e. the Trump administration recently sought to undo is in the process of trying to undo a key finding that basically said greenhouse gases endanger public health and welfare, aka the endangerment finding. And we also are at a moment where courts in the US are very skeptical of standing, and in particular this redressability point that you talk about, which is that if we can't solve the problem altogether, why bother? I mean, that's a real challenge in the US. Maybe a decade ago, when we had a different configuration on our US Supreme Court, we had, for example, an evolution of fundamental rights, like the right to marriage in the Obergefell case, that I think really speaks to the same kind of norm development about the way in which marriage has evolved over time, changing society. We can recognize a fundamental right. We are now with a different Supreme Court that is much more skeptical. And just as you said back in 1948, maybe the founders of the UN system, the writers of the UN Declaration on Human Rights, couldn't have foreseen everything. We are now at that moment here, and more fundamentally. Part of the reason why I listened to President Trump's speech at the UN was to just remind myself of how fundamentally he is pushing back on norms, key norms around diversity, equity, and inclusion that once upon a time were considered to be sort of sacrosanct. Norms around what it means to really be a good neighbor and to welcome, to be a nation of immigrants. We are seeing fundamental pushback on norms. And I would really love to maybe have a sort of your thoughts on this moment in time. Do you, given that we really have the rest of the international community in a different place than the US, to what degree do you see this kind of pushback on those norms from this administration actually being able to take root and be successful? So with that, thank you so much for this amazing talk.
Do you want to say anything, or should we?
Yeah, you have to say something quickly. Thank you for the comments, and I'm glad that you found that the book is helpful. On the right to water, yes. So that is definitely something that came up consistently in the interviews that I did. Many people, many of the normal entrepreneurs, very intentionally observed the evolution of right to water international law and said, well, can we do something like that for the right to health environment specifically? On normal entrepreneurs and sustainers, perhaps they can use questions 2 and 3, although they have to do with slightly different issues, but it's all about norm creation and evolution. And this is a dynamic picture. Of course, it's not like norms attain a certain taken for granted status, which is what international relations scholars say when the normative cascade has attained a moment of consensus or normative integration, because that consensus can be also questioned. And that is what is happening in this country now. So I have two observations about that. No, I wish I had a solution, but I have 2 observations. One is that for this particular legal field, the fact that the US is in, I hope, temporary retrenchment is not a fatal challenge, because human rights, as you said, human rights arguments have always had a hard time taking hold in the US. And there's a reason why that executive order didn't use their human rights language. You have to use the language that resonates in your legal culture. You have to use the language that you have support for in your legal system. And certainly, it's not just the US. In general, common law systems have a hard time with human rights arguments. And we've worked with colleagues in the UK, and some of the most interesting climate litigation organizations are based in the UK, like Climate Earth. And we've also worked with colleagues in Australia. Everyone would say that they would rather use other legal arguments, taken, for example, from private law, torts, securities, even in Climate Earth's case, even in criminal law, rather than human rights law. Not because they're not firm believers in the values of human rights law, but they know how kind of alien the logic and that language is to courts, and they want to win cases. So I would not expect this trend and even the number of legal actions of this sort to be affected by the ongoing political context in the US, which doesn't mean that it's not important. It's just that at least kind of the achievements in this field are not necessarily protected from those really worrying trends here in the US. Now, more to the point, and perhaps to the point of your third question or comment, is normative consensus or normative mainstreaming is the result of human efforts. Right? One of the things that I wanted to restore to this story is the role of human agents. And sometimes we as lawyers, when we talk in doctrinal classes, we take the law as a given. Like sometimes we don't have the time or the intellectual disposition to discuss the genealogy of the norms. And so we say, well, what is it? What's the current status of the law? What do I need to know to be an effective lawyer in this particular domain, criminal law, procedural law, and so on. I wanted to take a step back and show kind of the backstage action. And I said, it was not obvious that we wouldn't have a right to healthy environment in 2025. It took strategy. It took people's time and energy and good ideas to convince enough members of the international community to vote for that UN Human Rights Council resolution in 2022 and then the UN General Assembly's resolution in 2023. I was part of some of those conversations. I was by no means a leading voice in any of those developments, but I was privy to some of these conversations, and at the tail end, we did have a role to play as the climate law accelerator in lifting up some of those voices and giving this additional traction at the UN level. So I saw how people persisted for over the course of 20 years. Some of these folks that I write about in chapter 1 were there for the vote in the UN General Assembly when the UN General Assembly adopted the right to an environment as a human rights, as international human rights. So, because I'm a big believer in agency, and I think that we all are if we are part of human communities. I also think that just this backlash is also a very clear result of years of work on other people's part. Right, so this didn't come out of the blue. It wasn't just 2025. It was all decades long movement. So while this is probably not consolation, it means that this can shift. This is not the end of the world. So and the one thing that I can say, coming from the human rights, from my background in human rights movement, is that the human rights pendulum has swung many times. If you asked the Brazilian lawyers who litigated against and mobilized against the dictators in the 1970s, some of them are the ones coming out against Bolsonaro today, right? So because they know what dictatorship is like, that's probably the problem here. So when you know what an autocracy feels and looks like, you mobilize because you don't want to see that again. You don't want to see that again in your lifetime. And while some of these movements and counter movements sadly take years, I wish they could be more effective more quickly. I personally find comfort in understanding those long-term stories. And also in this case, quite frankly, some of these changes have happened very quickly. And the process leading to the advisory opinions really can be traced back to 5 to 10 years ago. It was not older.
Okay, thank you. We're gonna open it up to questions, and folks on Zoom, you are welcome to ask questions also. You can put something in the chat, or you can raise your virtual hand and I'll call on you, as it were. Yeah, Steve.
Unfortunately, I just heard about that you were giving this lecture about a half hour before it began. So I didn't know about your book, but I'm going to rush to get it because it sounds wonderful. My comment is that when you began talking about it, you talked about the fact that something that's originally proposed, any really interesting idea, is immediately rejected as impossible. I just want to share my experience with tobacco litigation, which went exactly that route. So 40 years ago, everybody knew you couldn't sue tobacco companies. It had been tried 20 or 30 years before then. It failed. Law professors are very smart, so they're able to come up with many, many reasons why it failed, why it was quite impossible. And I wasn't smart enough to follow all those reasons, so I just went ahead and pushed. But I think it is very, very analogous to what you're talking about in the book. Very exciting.
Yeah, very true. Very true. And as you surely know, some of the most interesting climate lawyers are looking very closely at the tobacco litigation movement and the precedents coming from the tobacco settlements to file new actions against fossil fuel companies, partly because the deception side of the story, meaning that many of the large emitters of fossil fuel companies, carbon majors, we know that they knew early on about they're doing it. They chose to distort the evidence and lobby against climate regulation. So there are parallels there that, and to your comment or to the response to your comment, there's also cross-layering across time. And luckily, some other scholars and some other practitioners have written about this or talked about this. And so one thing that one can do is not reinvent the wheel. But can we learn quickly from counter movements of the past, right? So against tobacco companies that we can repurpose for the challenges at hand today.
Yeah, I'm just wondering if you could speak a bit to the regional differences you're seeing in the types of climate litigation. You mentioned different legal cultures, priorities, politics. So what are you seeing coming out of Europe versus say Asia, Latin America, North America?
Yes.
To the extent you can
Yeah.
talk about that in 5 minutes.
Yeah. No, it's an important question. Very quickly, the reason why human rights-based climate litigation took off in Europe first and then Latin America is because you have kind of the perfect alignment, or not the perfect, but a more conducive alignment of, I don't know how much you know about these things in international law. So monist systems where that basically incorporate regional human rights agreements into national law, right? So it makes it easier for you as a Dutch lawyer to invoke the jurisprudence of the European Court of Human Rights or the European Human Rights Convention and say that to the government that they need to align their actions with the protection of the right to a healthy environment or the right to private life in the case of Europe. So it helps to be permeable to international human rights law. So that is one consideration. Then you also need, so that is the supply side, the supply of legal tools. But then on the demand side, you need a mobilized civil society, right? You need the lawyers, you need the social movements that can frame the scientists who can frame these claims in terms of human rights to bring those cases to the courts. And finally, in some jurisdictions, like in some Latin American jurisdictions, the evidence of climate impacts triggered a number of actions. In Brazil, again, the rising deforestation under Bolsonaro. In the case of of Ecuador, the evidence of eroding kind of environmental regulations. In the case of Peru and so on. And then finally, so those are these quote unquote structural conditions. And then, as I said in one of the showing one of the slides, people learn from each other. Right. So once you have a critical mass of legal actions, that creates a buzz. And people who want to be in the club, right? So they want to be in the club. So you say, well, I want to have one of those. And that is, I don't know if you've ever seen this YouTube video about the first follower, how movements are created. I don't know if you remember one thing from my whole talk, remember to watch that video because it's all about how you'll see how what really matters for social movements is not who leads, but who's the first follower. You really need the first follower. If we have time at the end, I'll show you the video. And in the sociology of social movements, there's a concept called the critical mass. So once you attain a critical mass, then you reach a tipping point, and then it becomes this movement. This trend becomes self-sustaining because now it's seen as the thing to do, right? So this is when the critics say, "I too want a piece of this," and by the way, I always said that this was going to be. And then
I wanted to ask about the sort of pie chart that you showed us, where many of the lawsuits, 90%, I think, are aimed at some form of mitigation, with reference to the Paris Climate Agreement, and only a small percentage of them are dedicated to climate reparations or some form of adaptation. Do you think that represents a limit of the litigation strategy in the face of so much immediate harm that's being done to people and the need for immediate reparations and adaptation? Or do you think that the scene will change?
Yeah, it's a great question. So I have different answers for adaptation versus reparations. So on adaptation, I just think it's a blind spot. Like the litigants should have filed more cases. So this is an agency side explanation, because if you look at adaptation, let's talk in kind of plain terms here. So adaptation means that a local community gets displaced by sea level rise because the government didn't put in place early warning systems, right? People didn't know that a hurricane was coming their way, that the flood was likely to happen. They were unable to take shelter in a timely manner, right? So that type of claim is very amenable to human rights arguments because you have specific victims in a specific place. And you can say, well, the government is to blame. So the type of perpetrator-victim action is clearer than in the case of in mitigation cases. Mitigation cases are hard to litigate, or used to be harder to litigate, because it's about drawing out carbon emissions, like from the climate system, right? And when you ask, well, who emitted all that carbon? Well, everywhere, everyone, everywhere. Right, so that's what made framing mitigation as a human rights issue difficult in the first place. So that would be my answer to adaptation. And partly because of the advisory opinions and because everyone has noticed this blind spot, not just me, I think there will be more cases on adaptation going forward. Now, on climate reparations, the reason is partly political, because the global north countries have pushed back really hard on norms on climate reparation. So if you look at the climate, the Paris Agreement, there is some language about adaptation, but any language about loss and damage is qualified in the strongest terms. Right? So, and there's a reason why after 30 years of global South government states pushing for mentions to loss and damage, it took well until the Conference of Parties in 2022 in Egypt for there to be any mention of a loss and damage fund in any agreement coming out of the COP process. Now going forward, climate reparations. That's Adam is an expert at this now because he was a part of the clinical group that put together a roadmap on potential avenues for climate reparation legal actions in the future. And I think that the advisory opinions are going to trigger a number of actions of this sort. The issue there is where to sue, right? What target to choose, because it's not to your point about the U.S. Even if, as is the case, many of the large emitters are U.S. corporations, probably suing in the U.S. is not the best strategic idea at this time, right? So you have to pair responsibility with feasibility of your claim, and then with fairness, right? Because a lot of people would not want to go. Some of the largest emitters actually are. You look at kind of numbers 10 to 20. You will see that many of the large emitters are state companies based in the Global South, right? Pemex and PDVSA and. Do I want to go after them, or if I can't go after Exxon? So those are the complicated issues of climate justice that you come across when you try to make progress on climate reparations. The ideal way to deal with this would be through a global fund that would dole out kind of compensations around the world, but this is not going to happen anytime soon. So I imagine that we're going to make progress, if any, through very imperfect partial litigation strategies, but they are definitely going to be incentivized by these two recent decisions into AOs.
I'm going to read the question from online. Given that the U.S. has abdicated its role as a leader in human rights broadly, and specifically in climate change, do you see a way in which we can bring other state global leaders like China into the climate conversation, especially around corporate accountability? I find it harder to find a path forward given the fact that Chinese corporations and the state are so closely tied, or does that actually provide a clearer path forward to incorporating China in the battle against climate change?
Yeah, because my perch from when the kind of the vantage point that I have here is climate litigation, I can say there's a reason why China doesn't feature in this story at all, right? Because bringing cases against emitters in China would have gone nowhere in that particular legal system. I don't think that's going to change going forward, and which doesn't mean that China cannot contribute to climate progress, but probably it will happen through climate economics, not climate accountability. China will not probably want to change its stance vis-a-vis kind of being sued in domestic and international courts for the emissions that they produce, which doesn't mean that they will not continue. They will take a larger role, say at the conference of the party system. I think that they're going to be more decisively kind of stepping into that space to partly fill the void and take the opportunity for global leadership that the US is basically giving up.
I guess I kind of have a follow-up question to that. Actually, I had another question, but I'll ask this one first. So you had a very nice pie chart that was, it was like, last summer I also did some work in climate accountability or corporate accountability, and specifically climate corporate accountability. And it seemed like it was most of the cases that you were discussing were against governments, and then there was like the 25% against corporations. And then there was that 4.5% slice of government and corporations. So is that the situation you're talking about right now with China, with these state-owned corporations? And it seems it started, like the climate conversation, at least in the US, started with people trying to bring corporations to account, and then that didn't seem to stick. That didn't stick for like attribution science reasons. Do you think now that the science has caught up, it will be easier and more like we'll be able to bring corporate accountability back into the frame in this way?
Yeah, in terms of the building blocks of climate accountability, I think the science is solid, the law is solid, but you need the politics. So this is a moment where climate law and climate politics are going in completely different directions in some parts of the world, including the US. which doesn't mean that progress cannot be made at the state level, which is why some of my students are choosing to go work for state governments, right? So and the Superfund laws are an example of that. There's a reason why the federal government is going after those laws, which is they're a form of climate accountability. If what you're asking for is kind of how to recover the losses, right, or the expenses of the climate adaptation investments that you're going to be making, right, the seawalls that need to be put in place to protect Manhattan from sea level rise. Well, and you have a legal framework to have fossil fuel companies pay up or at least contribute to those expenses. That is actually what a climate lawsuit would seek to do, right? And so I don't think that this is a lost cause at the state level. It all depends on climate politics and the balance of power between the federal and the state under the current circumstances.
We had a lively discussion in class, so I know. Yes.
Thank you. You talked already a bit about the effects of the US government science denial and how it's retreating from all of these commitments. But I was curious to what degree you're worried about civil actors also, like civil society actors also kind of taking that regressive role and eroding those norms, because your pie chart had like that small percentage of cases, for instance, where climate activists are being charged. Or we see, for instance, your book talked a bit about corporations trying to use this framework to resist regulation. As kind of science skepticism becomes more common among civil society groups as well, are you concerned that that could also kind of like coalesce into more and more regressive litigations kind of trying to co-opt this framework a bit?
Yeah, that's a great question too. So the short answer is that these trends work both ways, in all directions. There is no kind of fatal teleology to all this, meaning that there's no one, the arrow doesn't point in one direction only, right? So, and like with human rights norms, and imagine that you may have discussed this, they can be mobilized strategically to undermine human rights, right? Look what's happening now with the strategic use of kind of protection of human rights around the world to go and kind of for the US to become kind of a rogue actor in the international law. Likewise, and so everyone from fossil fuel companies to petrostates to anti-climate action movements, they also learn and they share strategies. So everything that I said was they also do cross-learning. They also enlist some pseudo climate scientists and so on. Right? They also they also forge alliances with lawyers and think tanks and so on. And this comes down to the correlation of forces. Sorry to be such a kind of old-fashioned sociology here, but it's a sociology student and professor here. But it's a correlation of forces between different social movements. Definitely. What I can say is that in countries ranging from the UK, which has really draconian laws against climate protests. This is why you have folks from Extinction Rebellion and others in jail. And you saw what happened with Greenpeace US, getting sued by fossil fuel companies, losing a case that might cost them like hundreds of millions of dollars, right? So there is no end to the cross-learning. It's not the kind of the conservative counter movement is also not fatally determined to succeed. And the question is, well, what is the wisest, the most strategic reaction to all of that? And there are lots of people doing all kinds of interesting things, from passing anti-SLAPP lawsuits in countries like the Netherlands, or countering climate misinformation, which is one way to block kind of or to stop one of the streams flowing into the counter movement that has reacted against the successes of this movement that I'm speaking about.
You talked a little bit how people tend to look at this area with a glass half empty approach. So in the effort to look at this with a glass half full approach, how do you potentially see the cases that are on appeal or still pending and sort of the litigation strategies overall changing now that these two advisory opinions come out? And do you have any sort of hopefully positive ideas of how the litigation is going to change, potentially change moving forward, whether that's drastically or kind of tweaking strategy here and there?
Yeah, I definitely have a glass full view on that, because many of the courts that will be deciding those pending cases are actively, if they haven't already read those AOs, they will, and they will be, as courts tend to be, not only inspired but feel protected by having kind of that halo of authority emanating from the highest court, especially the ICJ, but also definitely the Inter-American Court in the Latin American context. So I would anticipate that the pending cases, no one will ever know what difference the AOs made, but I would think that they will tilt the balance in favor of some of the claims being advanced by the plaintiffs in these cases, and also that many more cases will be filed, which very directly and very prominently will invoke those two advisory opinions. So yes, I think that that is something that can be said with a lot of confidence.
Like 1 minute left, and I kind of think like that's an up note. So yes, but my class is never end up. So thank you so much. And